Ladies and gentlemen, I think uncharacteristically we will kick off on time today, and a very warm welcome to you to our second gathering of the year. And it's quite a feast today. We have, I think, 7 speakers. We're every day every time we have a meeting, we break a new record with the number of speakers, I think. And we have 7 this time, but they've got 5 crucial minutes to get the message across, which we'll see if they succeed in doing that. This is a really interesting and important session on the whole area of GDPR. I mean, what we're really trying to do is kick the tires on data use, data sharing, data value, commercialization, use by third parties and so on, and no doubt we will get onto the subject of data trusts as well, but there's a whole area which is really of crucial importance in the world of AI currently, particularly given the form of AI that is the most popular, which is machine learning, which uses huge amounts of data. So data currently really is the focus of a great deal of discussion. We've obviously know that there's quite a lot of work being done by the Open Data Institute at the behest of the Government Office for AI, and so on and so forth. So we're going to unpack all of that at what I hope will be fairly high speed. I think do we have the final one of our speakers? We do. Perfect.
Oh, wait.
Well,
turn that speaker her chair, yes?
you can come and sit here if you like, Susan.
Right, I'll stay on the sidelines.
Okay.
It's been a long day, the brain's not functioning.
So do take a seat. We have another 2 seats for parliamentarians, but if we don't get parliamentarians, we'll liberate them, democratise the chairs here in due course, because I know that we always have a room that's far too small for the numbers present. Right, well, I'm going to kick off, and we're going to start with Dr. Florian Ostmann, who's the Policy Theme Lead and Policy Fellow at the Alan Turing Institute.
Thank you very much. First of all, it's a pleasure to be here. Thank you very much for the invitation and for spending this time with us discussing these important topics. There's a lot that could be said about tonight's theme, so I thought I'll focus on 3 particular issues. I should briefly probably say a few things about sort of my background, where I'm working. So the Alan Turing Institute is the UK's National Institute for AI and Data Science. Our headquarters are here in London, but we're a network of around 500 researchers all across the country, located at different universities. So I'll partly speak to today's topics based on a researcher experience and the challenges that arise in a research context. But I'm also more specifically a member of the public policy program within our institute, where our work is focused on 2 areas. The first area concerns the governance challenges that arise in the context of data-driven technologies. We're doing work at the moment, for example, together with the ICO and the FCA on these issues. The other area of work concerns the use of data and sort of the realization of benefits of data use in the public sector and in pursuit of social good more generally. And so I'll use some examples from both of these 2 areas to illustrate the points that I'll be mentioning. So the first point that I thought I would briefly address concerns consent in the context of collecting and processing personal data, and specifically the challenge of ensuring that consent is meaningful and informed. So I think we're all aware of the fact that in the course of GDPR implementation, there's been a huge increase in the attention and on processes that ensure formal consent. Consumers ticking boxes and clicking OK on terms, on conditions. But I think an area where there's a lot left to do is to ensure that the consent is actually informed and meaningful. I think we all know from experience that all too often we click on a, accept terms and conditions box without having read the terms in detail. And one area, I think, in which this is particularly important is areas where the very same data can be used for beneficial purposes, but also harmful purposes. So an example from financial services, for example, is the use of data around vulnerability on the part of firms that could be used in a way to protect consumers, to support them in for example, certain mental health challenges that they face. But the very same data could also potentially be harmful in terms of negatively affecting credit ratings and so on. And so in order to enable the beneficial use of that type of data, it's very important to provide assurance to consumers that data really is only used in a beneficial way and not in ways that is harmful. And that's a challenge in terms of ensuring appropriate governance, but just as much it's a challenge in terms of actually communicating to consumers that, what the uses are. And I think, that can't be effectively done in the current way of just providing a, pages-long list of terms and conditions. And we really need to think about best practices to communicate in concise ways at a glance, sort of what the uses of data are. So that's the first challenge. The first topic. The second topic that I briefly wanted to mention is the role of privacy-enhancing technologies in the context of data sharing. So I know that the concept of data trust has already been mentioned, and I know that this group has looked at the concept of data trust and related ideas in the past. So those ideas concern, in a way, the organizational prerequisites for sharing data. But there's also a technological angle or technological contribution to reducing obstacles to data sharing. And one example for that are privacy-enhancing technologies such as differential privacy or federated machine learning. They can be very effective at addressing some of the concerns that are in the way of data sharing, parties agreeing to data sharing. But there are two challenges at the moment. The first one is that all of these technologies are in the infancy, and there's a lack of best practices and established standards and sort of general knowledge on the abilities and limitations of these technologies. And secondly, there is a lack of clarity, I think, from a regulatory point of view, in terms of what the implications are of these technologies, and especially when it comes to distinction between personal data and anonymized data, at what's the risk involved in using these technologies, and should they be, how should they be thought of from a regulatory compliance perspective. I think I'm running out of time already, so I'll just be very brief on the third point that I wanted to share, which is a point on the distribution of value when it comes to the use of personal data. As we all know, personal data governance debates tend to be focused on control and consent, and also very important issues, of course, but they leave unaddressed what I think is another important question, which is, who benefits from the use of personal data, especially in sort of economic terms. One way in which this is often discussed is in terms of the question, should consumers be paid for the use of their data? But that's just one particular angle that one might take. There are other questions to raise, for example, from a competition policy perspective. There's increasing recognition of the fact that depending on the level of competition in a service economy context where services are for free and revenues are generated through data processing, depending on the level of competition, the same service may be provided for a lesser or a greater degree of privacy interference. So it's important to bear that value dimension in the exchange in mind. And then, of course, there are also questions around patent protection or profit that's derived from products that are developed on the basis of personal data or more generally publicly available data, and how that value is shared in the economy.
Florian, thank you very much indeed. You've mentioned two very important areas there at the end of your remarks there, the challenge of privacy-enhancing technologies and the question of distribution of value. I mean, the Turing is obviously an extremely powerful institution in terms of the research brains that it has access to, but in terms of priorities, I mean, where would something like the whole question of, in a sense, developing these privacy-enhancing technologies which allowed individuals to have greater control over the sharing of their data and indeed the creation of data. I mean, how high up the scale of priorities would that be for the ATI?
It's very much at the top of our agenda, both in terms of generally contributing to this as a field of research, but also in terms of using those technology for our own internal purposes. So we often, a lot of our own research or the largest part of it is, of course, based on data. And so we're often faced with the challenge of getting access to data with the parties that we're collaborating with, be it in the public sector or in the private sector. And so we're very, very strongly looking in those cases at the use of different forms of privacy-enhancing technologies to enable that.
So this isn't a question of, say, the Government Office for AI or some other body or the Centre for Data Ethics and Innovation saying this is something that we are prioritising. You as an institution are prioritising.
Yeah, absolutely.
This.
Yeah. And I think there's as much, I think all of the parties you just mentioned have a role to play in this debate. There's an important role for actually, substantive research in advancing these technologies and getting clarity on their limitations and abilities. And then there are the more sort of policy-related questions in terms of what to make of them from a compliance point of view, in terms of compliance with personal data protection rules.
Great, thank you very much. And now on to Dr. Kenan Direk, who is the Research Data Manager of the Institute of Health Informatics at UCL.
Thank you. So it was a fantastic introduction by Florian. I would also like to extend my thank you to the organisers for their invitation to give my perspective on data governance within the academic research space. As you said, I currently work as a health data manager at the UCL Institute of Health Informatics, whereby my interests are centred on the use of national electronic health records of 35 million and more people to provide real-world evidence that hopefully impacts public health positively. So on some of the points Florian raised about the public benefits to these, to sort of using very large data sets, using AI technologies. So I thought it would be useful to provide some context into what sort of studies we are able to do in terms of using health data in that sense. So I've listed three that in my opinion represent the very best of what we can achieve given access and the correct tools and infrastructure and sort of governance policies around health data. So the first, and currently sort of the only chronological map for over 300 physical and mental conditions. So this is a very important epidemiological question in the sense that it's very important to understand who gets what disease at what point in their life. So you can use that to inform resource allocation, again, sort of policy work, sort of to reach out who needs the most sort of resources at what particular time. The second that I found very interesting was the use of over 100 million primary care consultations to indicate clinical work may be approaching saturation. So this sort of study prompts questions on sort of how the nature of the patient and the GP interaction must evolve to contend with current and future demands. And finally, and this is something that's very sort of new and ambitious, there is a piece of work going on at the Institute of Health Informatics that uses routinely collected information to better understand the health of over 1 million migrants in England. So like I said, these studies represent the very best of what I think we can do with this data, but it's a good question to ask, how are we able to do this? Have millions of people consented to their most private, personal, sensitive information being used for research? So in short, that answer is no. But under the GDPR framework, the lawful basis for this type of activity is outlined in Articles 6 and 9 that collectively describe legitimate public interest in the process of non-consented data for scientific or public health research. So within that remit, we may be interested in potential drug side effects that have not emerged during clinical trials, or drugs developed for one indication being repositioned or repurposed for another. So these are very important benefits that by using this data we can positively impact public health. So therefore it's not surprising that health data is sold to academic and for-profit organizations to achieve, to perform this type of work. But unfortunately unfortunately we've sort of lost the transparency with each of these transactions, and that sort of breaks the social license placed upon us to use this data in a fair and open way. So I'm just going to finish on the point of what sort of I believe in sort of like the ethos of sort of how we use data is that if we are to realize a true potential of using individual health data at population scale, and I completely agree with Florian's point that there has to be genuine, meaningful engagement with between the public and organizations that can translate data into products of therapeutic value. So we have the tools to conduct health data research securely, and again, I agree they might be in their infancy. So I am sort of, and something that Turing is leading on in terms of data safe havens, which I think are fantastic. But we don't bring patients and the public with us on this journey. So I just want to end on the point saying what I think sort of the health research environment or sort of health data could look in 5 or 10 years. So it's not impossible to conceive a landscape where data never has to leave the health service that benefits both the patient and the researcher. So the patient can see what data is stored on them, what's that data used for, and how is it collected, and what companies are using it. And for the researcher, to have the sort of the largest and most comprehensive medical database available in the world, and that's a very exciting prospect, but that can only happen sort of if we have the correct data governance and policy structures and regulation in place, and we have the most advanced sort of e-infrastructure around things like safe haven and data trusts. That was my...
Thank you very much indeed. You'll probably get quite a lot of questions on the health front because, of course, there's been quite a lot of publicity about sharing data with American pharmaceutical companies and so on and so forth. But let me just ask you about the actual outputs of your unit at UCL. I mean, in terms of your interface with the NHS and, recommendations about transparency and so on and so forth. I mean, how do you express that in governance terms? I mean, or are you, on the other hand, really advising about the coherence of the data sets, about the way that they can be used for certain purposes and so on and so forth? I mean, how far do you actually get into governance recommendations?
I think, and I may be wrong, but I think one of the key roles that researchers in sort of at the institute have is that we're able to sort of draw insights into data that's routinely collected and wouldn't sort of otherwise be used, and we can turn around that insight into informing policies. Again, like a very new study, but something we're working closely with an NHS trust is that we want to return genomic results back to sort of routine care, and that's something that's never been done before, and sort of there are, as you can imagine, a lot of legal and ethical challenges how we do that.
When you talk about doing that, because obviously in a sense you've got a very strong clinical desire to get these things made use of, to get the data made use of, but how does governance travel with that? Do you make recommendations on the governance at the same time?
Yes, because we would not be able to sort of do the stuff we do without those governance tools at our disposal, and sometimes where they're should we say lacking, it's important sort of we highlight and say that in practice, if we are to do the things that we set out to achieve, we need a change or some sort of modification of those guidelines, and we're able then to report back to sort of the appropriate advisory groups.
Thank you.
Thank you.
And now on to Tamara Quinn, who's a partner, intellectual property, data and AI at Osborne Clarke. Tamara.
Very much. Yeah, so I'm a partner at Osborne Clarke. We're a law firm headquartered in London. We've got a network of overseas offices. As Tim mentioned, I specialise in IP and data. I'm part of the firm's AI and machine learning team. So I come at this very much from the point of view of a humble practitioner advising clients on their practical, real-world, day-to-day questions around the development and use of systems involving AI and machine learning. So I'm going to talk about two things today. intellectual property and questions around ownership of data used in machine learning systems, and also touch on GDPR and some of the issues arising from its application to date. So intellectual property protection, so increasingly the data sets upon which systems can be trained are recognised as an important assets in their own rights. And as was mentioned in the European Commission's data strategy paper that was published last week alongside its white paper on AI, one of the concerns which is slowing business take-up of AI is uncertainty over what IP rights there are in data itself. And it's worth understanding that most companies which generate or collect data, they're not AI companies, they're not even technology companies. They certainly don't see themselves as even in the data business in many cases. So that's where a lot of our potentially valuable data is sitting. And collections of data, and particularly non-personal data, may be merely generated as a more or less unnoticed side effect of the day-to-day business operations of these companies. If you think of the so-called digital exhaust of information that's sort of belched out by our increasingly connected environment, that's the sort of thing we're talking about here. So when we talk about data ownership, what IP protection is there for data? The reality is that it is pretty patchy. It's different from IP protection for the AI and machine learning systems themselves, where there can be quite good protection in terms of copyright and patents. It's really quite different for data. And what we're forced to rely on is really a bit of a patchwork of database rights, if they're available, confidential information, trade secrets, and obviously we try and bolster that with contractual obligations where we can. But I think it's worth just mentioning that database rights, despite the name, are actually surprisingly limited in scope. And to qualify for protection, without going into all the details, the creator of a database has got to make substantial investment in obtaining, presenting or verifying the data in the database. So this will cover things like spending money on already existing data, seeking it out, compiling it, verifying it, cleaning it up and so on. What it doesn't generally apply to is investment in creating that data in the first place. So this means that the sort of database I was talking about earlier will often just not be covered by the database right. So I think that's potentially an issue, and I think that means we ought to at least look again at the question of whether we ought to be making any changes, modifications to IP law to broaden the protection available for data sets. I'm very cautious about pronouncing as to whether we should have increased protection, but I think it is something that is worth looking at. And what really matters in any event, whatever we decide to do, is clarity, creating clarity for businesses so that they can spend their money on going about their business rather than delightfully spending on lawyers trying to work out what protection they have. So then just moving on to application of the GDPR to date and what conclusions we can draw. So to date we've had quite a lot of guidance from the ICO, the European Data Protection Board, not so much in terms of formal enforcement or through the courts or through the ICO. Aside from, there obviously have been some high-profile enforcements around data breaches and so on. But what I want to look at instead is just what we as lawyers see in terms of the application of GDPR, because that's the application of GDPR by companies and organisations. And there are some very well-rehearsed issues which people have come across around automated decision-making and obligations to inform people properly, providing meaningful information. I think those are quite well known, so I won't go into them. But I just want to make it clear that these are not the only GDPR issues that apply in relation to AI and machine learning. There are lots of others as well, and just to give you an idea and focusing on the sense of data as an important asset which we should be trying to enhance within our economy. If you look at Article 28, and these are the rules governing relationships between controllers and processors. So this is where one entity is processing data in some way on behalf of another. So there's quite strict rules governing these relationships. And what these rules say in very shorthand form is that if the entity that's meant to be just doing the processing, in fact, makes some use of the data for its own purposes rather than for those of its customer, then that person, that entity becomes a controller in their own right, which effectively, again in shorthand, puts it in breach of GDPR and in breach of its contract with the controller. So if you think this through, what it then does is this is effectively inhibiting the processor from using this data to train, improve, optimize the very machine learning systems which are meant to be performing the processing of the data. And this will be the case even if, for example, the processor were to fully anonymize the data before it did this, it would still potentially be in breach because the very act of processing data in order to anonymize it is itself an act of processing, which is being done for the benefit of the processor, not the controller. So you're back into a breach situation here. So I think there are real tensions here between the application of the GDPR and what we're trying to get out of it for society. I will mention very quickly just one last thing, because I know we have someone from the Information Commissioner's office right here, which is just to bear in mind.
Lobby as much as you like.
I'm definitely not lobbying, because I think different people want things in different directions, and that includes all of our clients. But I think obviously the ICO has to make some very tough decisions about where it's going to apply its resources, and I don't pretend for a moment to have any insights into how best to do that. But I think it is worth just bearing in mind that I think we shouldn't underestimate the extent to which GDPR compliance in real life is informed by what you might call market practice. And I think when there's a relatively small amount of enforcement activity, or at least publicised enforcement activity around certain aspects of GDPR, you can risk creating a bit of a sort of laissez-faire attitude among some organisation. And so, just to put it into context, if an organisation which might be trying to do the right things sees its competitors behaving in a way which is inconsistent with the GDPR, and then doesn't see anything being said about this, any regulatory action being taken, it makes it quite hard internally for the people who want to do the right thing to actually persuade their company to do the right thing. Sorry, I'll stop there.
All right, that's great. You've kicked the tires. I talked about kicking the tires in the GDPR, and you've created a few holes in those tires by the sound of it. I'm sure that Ellis will respond. But we are in an interesting situation where, of course, we are shortly going to be a very separate jurisdiction from the EU. So that creates its own particular issues, not only on things like database rights, but also on the GDPR. In the best of all worlds, how would you proceed?
I think it's a really tricky one, because it's like everything else around Brexit. On the one hand, this potentially gives us the freedom to create the rules in a way which suit our economy. On the other hand, we are very, very closely entwined with the EU 27, indeed the rest of the continental Europe. That's not going to change in future. It may go. So I think there is just an inherent difficulty between trying to take the benefits of Brexit and being able to do what we want, and on the other hand, making sure that we're still aligned for practical purposes with what's going on in Europe, because companies are going to be affected by that.
This is going to be clear, decisive advice to government, basically, is it?
Well, you've got to decide how you want to have your priorities.
Great, thank you very much. Ellis Parry, who is the Data Ethics Advisor at the Information Commissioner's Office. Ellis.
Yes, thank you. And just before I launch in, I would like to build on something that Kenan and Tamara has said. We do think extensively as a society, about the ethical implications of the secondary reuse of health data. And I wonder whether sometimes we aren't overlooking almost the ethical imperative to, as you said, analyse that data and feed it back for the treatment of society overall. And it is very interesting that you can't own data under English law, this fabulously valuable asset that actually can't be owned traditionally under English law. Anyway, that just occurred to me. Thank you very much for the opportunity to come along here today to share my thoughts on this very interesting topic. So I am Ellis, Parry, the Information Commissioner's Data Ethics Advisor, struggling with a brand new pair of bifocals, so they will be on and off at will, really. The Information Commissioner, for those of you who don't know, is the UK's independent information rights regulator. Elizabeth Denham is committed to increasing the public's trust in what happens to their personal data, this commitment forming the basis of her information rights strategic plan through to 2020. So the ICO's remit, again for those unfamiliar with it, includes the following legislation, amongst others. There's quite a raft of it: the GDPR, the Data Protection Act, freedom of information, and the reuse of public sector information regulations also. We've been talking about the secondary reuse of information. So my role at the ICO is to articulate the interplay between the data protection principles over which the ICO has regulatory oversight and the emerging field of data ethics, and communicate and consult on those views, which I will be doing over the course of this year, raising awareness and hopefully buy-in to the mutually reinforcing nature of those concepts which underpin each of those disciplines. So I have been in the post, I'm relatively new, I've been in post since November 2019. By background, I'm a solicitor specialising in information law rights. I've been doing that for the past 20 years. And prior to joining the ICO, one of the roles which I had the great privilege of holding was to be the compliance lead for a pharmaceutical company, advising again on bioethics and data protection. So as the rate of data creation increases at an exponentially escalating velocity, and the possible use cases involving AI and machine learning evolve too, the undoubted benefits to society of this novel processing and the value it can return is widely recognised. It's been referred to as the fourth industrial revolution, and so while the benefits are easy to articulate, so are the risks. The EU Commission's white paper, which Tamara mentioned on AI, which was published last week, draws attention to the potential benefits, particularly in healthcare, but it also goes on to talk about climate change mitigation, predictive maintenance of machines, agriculture, energy, transport, and combating environmental degradation, all very important areas. However, as the second recital of the Data Protection Directive, for those of us in the room that remember that, opined way back in 1995 now, data processing systems are designed to serve man. Technology should be serving mankind in order to improve lives while respecting fundamental human rights. There's a degree of alignment about the risks posed by AI and machine learning performed on personal data, and the following list is not exhaustive but is merely illustrative of some of the bigger risks over which there is most consensus. Opaque decision-making, sometimes referred to as black box, which can challenge openness, transparency, and explicability, entrenching discrimination through data bias, unwarranted intrusion into private lives, and challenging human dignity and autonomy, as well as threatening potentially pluralism and inclusion. So the EU, they use the phrase, the Commission uses the phrase, trustworthy AI. It is a prerequisite that AI is trustworthy to its uptake and to unlocking the benefits of this revolution. We engender trust by being transparent about the risks and by explaining how those risks are being mitigated and managed. If the risks are identified, mitigated, and the success of that governance is subject to ongoing monitoring, then the benefits can outweigh the risks. As a report launched on 10th of February by the Committee on Standards in Public Life makes clear, the Nolan principles for the public sector can flex to govern these challenges posed by AI. But AI does pose challenges, in particular, to openness, accountability, responsibility for the decisions that may be taken and for the provision of meaningful explanation and redress, and objectivity, data bias, again, perpetuating discrimination, potentially. So the committee recommends that the government issue an authoritative set of universally applicable ethical principles, while obviously acknowledging all of the good work already done by, I'll blow our own trumpet, the ICO, but the DCMS, the CDI, the OAI, and of course the ATI. That is not very easy to say. That was the bit I was most nervous about, was simply getting all those acronyms out. So these universal ethical principles could bridge any gaps between the rapidly evolving new technologies and the governance set out for the processing of personal data under the GDPR, the text of which was, it feels like a very long time ago. It was 2015 when the text was finally agreed. So to conclude, the rigid construct of the black and white letter law may not sit easily with new data processing possibilities, leading to a perceived gap in the GDPR's ability to stimulate and not stifle innovation. Ethical principles representing flexible consistency through periods of rapid change could usefully guide organisations towards a correct operationalisation of the GDPR's principles, even in these new novel times.
Thank you very much indeed. You mentioned, the Committee on Standards in Public Life. It's a very good report that they came out with. And you also mentioned all the various bodies in the field. And the question, I think, in a lot of people's minds is, how far does the writ run of the ICO, basically? I think we understand quite a lot about its ability to insist on data impact assessments and so on, to levy fines in the private sector. I think a lot of us are not that clear about how far your writ runs in the public sector. And of course, the Committee on Standards in Public Life was commenting specifically on algorithmic decision making and so on in the public sector. But I think that people think that the ICO can insist on certain forms of behaviour in government, but I don't believe that's the case, is it?
Well, the ICO has enforcement powers that are corrective or investigative or indeed punitive. And I think it would be preferable if the Information Commissioner had concerns to seek further information from the organisations where the concerns were being raised, rather than immediately leap out to meting out fines, which is a possibility still.
But that's a very diplomatic answer. But
at
the end of the day, you can't force government to do anything, can you? Despite the framework for data use and so on and so forth.
No, obviously the Commissioner has a very strong voice within government, which is persuasive.
Great. The more persuasive, the better. Good. Thank you very much indeed. And now on to Andrew Pakes, who's the Research Director at Prospect.
Brilliant. Thank you very much, Chair. I'm very honoured, pleased to be here. Certainly, again, you pack in the audience every time. So, firstly, I'm very relieved as your fifth speaker that I'm going to talk about something different and not repeat what the others have said. I'm less relieved because I'm breaking in varifocals. So I'm going to try and keep them on as opposed to take them off for my thing. So my name's Andrew Pakes. I'm the Research Director of a trade union called Prospect. I'm going to talk about the issue you probably think, which is work. Prospect is an independent trade union that represents 145,000 members across science, specialist professional roles, and many workers in technology. And my contribution's based on a double insight of our members, both because an increasing number of them are involved in the design of machine learning and new technology solutions, particularly those who work in public service and some of the big public service agencies. Secondly, an increasing number of our members are on the receiving end of new technology coming into the workplace. So I'm going to speak, Florian spoke from research, I'm going to speak from some of our perspectives in terms of worker experiences and employees. So I think my main message is that in this debate we don't talk about data and work enough, and it seems to be one of the missing areas when we talk about it. Much of that discussion around data and GDPR is primarily based on individual rights, and that's important for us as citizens. But the contractual relationship of work is different to our citizenship rights. It's different to personal data. There's an asymmetry of power. There's aggregated data. There are decisions and consent and choices which people are asked to make individual choices are, which is fundamentally different to me sitting in my house deciding what Argos or B&Q should know about me. The level of decision making or power is different to that. So we need to understand how we talk about some of that. And I think a couple of the speakers have talked about value, and I think that's an interesting concept for us. And we tend to put value and ownership together. But both of those things lend to a very British end of the debate, which is about individual rights. And what we don't seem to talk about much is value and collective or group rights. And I think that's really important when we look at what that means in terms of work. So the focus that we've been looking at as a union is particularly on what we now call people analytics. My mum would call it HR, or time and motion studies, but it's the new world of this, and how data is changing workspaces. So if the 20th century was primarily around regulation between people and management, or employers and workers, what we don't have yet is really a framework which is between people and their data, and how those things go together. And the risks if we get this wrong are legend. In the last few days, I was looking at this, we've had the tech clash, we've had the stuff around Barclays, we've had the news articles around US companies doing health monitoring and checking how much people sleep at night. All of this datafication and monitoring of work, unless we have some concept of group rights, risks leading to a position where secondary levels of data, other bits of data, actually are used to make decisions about people in terms of their work, where there is no balance of power or sharing within that. And I say clearly, our members are pro-technology. We approach this as a union in that we think technology is good, we want to embrace the future of work, but we feel we need to get it right. We did a survey of around 7,500 of our members in specialist and technical roles in January. Half of them said they were not confident that they knew what data their employers collected about them, even with GDPR. A third of them were concerned that data was being collected and it may not be used for good purposes, and a whopping 75% said that they did not feel they would be involved in any conversations about how technology would be change their work and how that happened. So again, top-down change rather than some kind of co-creation in that. Chair, last week I was at a very similar conversation to this with a group of businesses and unions in the Nordic countries, where they approached this very differently to us in terms of their approach. And people may be common with the art analogy of accountability, responsibility and trust, and I think that's really important. Trust, really important concept. I was very taken by a contribution by a speaker called Professor Virginia Dignam, who exposed on that and asked a series of questions which I think relate to us and to this work, which is that with accountability and responsibility and trust, they can sound like good things, but where does consent lie? Who decides who has a say? How do we make choices and trade-offs between conflicting values? And how do we verify whether the design systems embody intended values? I would say, where do workers sit within that? Because we have some very good specialist bodies, but if we want to make trust happen, if we want to make change happen at a workspace, there needs to be some mechanism where workers, not just unions, but workers themselves, there's a range of mechanisms for unions. And I'll finish by saying this. I was very taken by the contrast between the EU approach and the UK approach. And we'd be very worried as a union that this will be, that we're in a position where we may end up weakening our commitment to data rights and data governance in the years ahead, whereas the EU is seeking to build up their rights in trade deals and others. I was taken by this quote in the digital strategy last week from the EU, which says, "Beyond upskilling, workers and employers are directly affected by the design and use of AI systems in the workplace. The involvement of social partners will be a crucial factor in ensuring a human-centred approach to AI at work." If you contrast that to British government policy, to the government's AI strategy, workers are not regarded in official government policy as having any voice in change. We are regarded as people who will receive training as though we are widgets in the economic model, rather than we have autonomy and concerns about how our data may be used. And my premise would be, if we wish to benefit to the greatest degree as a country and as an economy, then we need to look to how they are doing this in Europe based on partnership than we do compared to America, where they're doing it based on imposition.
Great, thank you very much indeed. A very good rallying cry. And of course, the EU emphasised last week, did they not, that the humans in command approach was one that they've talked about before, but they wanted to keep emphasising that. So you're absolutely right. I mean, the question in my mind is, you've obviously thought about this a lot on behalf of your members. It's of considerable importance to them. But where do you go from here in terms of either greater numbers? Is this a matter for the ILO or, you know, let alone the TUC? I mean, is this something that is taking on a life of its own in terms of policy making beyond, you know, your shores, so to speak?
Absolutely. Part of that, you know, my learnings from visiting our Nordic colleagues was to see how they're handling this at business to union level, so bypassing government because the social partners want to make this happen. We've got colleagues in Ireland who have now inserted into employment contracts data control rights at the Royal Bank of Scotland, at Ulster Bank. We have an agreement with Telefonica in the UK on the right to disconnect, which was agreed jointly with European unions about the ability to switch off and not be monitored when you're outside work. So there are small elements. What I think we would enjoy as part of a healthy debate in this is more of our national advisory bodies, ICO, CDI, looking more clearly at the employment relationship and what that means for data. And for us to be working, I think all unions to be working harder to raise this as a question with yourselves and others. So there's a job of work for us to do as well as others to join us.
There needs to be a simple way of plugging into some of this knowledge and practice, if you like, as well, doesn't there? Whether at a European or at a sort of OECD level, you know, whatever it may be. But there's clearly more to be done in terms of that communication.
You know, our members are very certain that there are shared benefits for everyone in this, in terms of productivity, quality of work, and the excitement we can bring to the economy, but we've got to make that shared.
Yep. Great, thank you, Andrew. And now we're on to James Kingston, who's the Deputy Director of HatLab.
Good afternoon. Thank you very much for having me along. So my name is James, as you will have gathered. I should say a couple of words about the exciting venture that is the HatLab. So the HatLab is the innovation space and advocacy hub of the hub of all things ecosystem. Really trips off the tongue there, hence why we use the term hat. The hub of all things ecosystem is a system designed to promote personal data accounts. The ability of individuals to use personal data accounts to flow all of their data into one particular space upon the cloud and then own their data and transact using their data from there. Everything we do is designed to promote that vision, both within the HatLab itself as an innovation center and other spaces within the system. And we do that because we see this as the best way of promoting, broadly considered, data rights as a whole. Now, what do we mean when we say data rights? Well, obviously, there's privacy. We have a number of privacy promotive systems inside the hat, as we call it. But also, more importantly, it means ownership and mobility. And I'd like to get into that a little bit more. Now, one of the questions we were posed when looking at this evening was whether or not data is a commodity. I think this is a potentially problematic idea. I mean, data is, of course, very subjective. It's immensely private. It varies incredibly. What I think we should really consider data as being is not a commodity, not oil, particularly because you can keep on reusing it, but is a store of value. Data is a store of value. And so what you need for this store of value, is this potential source of value, I should say, is a place to store it. But where does its value come from? The value of the data comes from movement, from your ability to transact and do things with that data. Simply having an inert store of value somewhere where no one can touch it, that isn't going to help you very much. Be you a gigantic global conglomerate, or be you an individual that's striving to realign the value hierarchy of the internet. To us, ownership means, well, as a classic definition, rights and property, but for us, more importantly, rights and property and a sense of agency. Everything we do in the HAT system is designed to promote that. When we think who should own data? What's a model for data ownership, as we opposed in the brief for this? Well, I mean, there's a few candidates, isn't there? I think at core you have the notion of it being either the collector of data or the generator of data, i.e. either the company that's setting the system or the person who's interacting with the company. These are all interesting questions. One of the fascinating things about this whole system is the way it forces you to really consider deep questions of political economy. And I think similar to the way people have defined property in the past, so too we can see it being defined in a similar way today. In the past, people have talked about communal data rights, collective data rights, and individual data rights. Of course, we now have the concept of the data commons, data trusts, which I know have so often featured in the reflections of this panel, and then individual property rights. Well, as is probably clear by now, the hat is all about promoting individual property rights, as we believe that this is the best way of shaping an internet that has the interest of individuals and society as a whole at the core. Well, what do we do, having prepared you over the last 3 minutes, 40 seconds with that teaser repeatedly? We give people databases. We give them a space to access that database right that was mentioned earlier, and to actually have that substantial investment of effort required to earn it. And we give them a contractual system to help them along with that. We give a consent-driven system for people to consent to potential transactions to make sure that everything is GDPR compliant. And we enable the co-creation of value between individuals and between the companies with whom they transact. This, we would say, is ultimately a common good, just as much and even better than we would say any data common could be. We have this notion of whether or not data can be democratic. I smiled when I saw this question because ultimately, what is democracy? And as that question also posed, what is harm? There are many different forms of democracy, but in the hat, we strongly believe that the best way of ensuring beneficial outcomes for all is by property rights and by spreading property rights widely through society. Because this is what will enable the protection of privacy, will enable individuals to realize value, and ultimately will enable some sort of redistribution of value, as we had heard as an important question in the first talk. Thank you.
Thank you. A lot of very interesting questions arise there, particularly as to whether there are more sort of bells and technological whistles that need to be added, or whether, in a sense, it's the finished article as it currently is, i.e. you've got the portability, interoperability, and so on and so forth. And, we don't need Florian to be toiling away in the basement at the Alan Turing to develop more technology in terms of the way that data is shared and so on. I mean, it sounds a wonderful way of an individual having control over their own data. But is this a beta product at the moment, or do you think it's roll-outable, if that's a word that I can use at this very moment?
It is most certainly roll-outable. If anyone is interested in learning more about working with the hat, either as an individual or in respect of an organisation, then please come and chat to me afterwards. We're certainly out there and looking for collaborators. And
platforms and others, in a sense, when somebody's approached and say, well, I want, to make sure that my hat is actually, the instrument by which I share my data, or it might be a health trust or whatever, people are becoming familiar with that when people say, I have a hat and I want you to interface with that?
Yes, I mean, people are becoming increasingly familiar. There's two sort of ways with which people can become familiar. There's obviously there's going on to the hat community website and getting a hat issued for yourself as an individual. One of our partner organizations within the wider ecosystem, DataSwift, also enables organizations to build data rights-centric backends by offering the hat as backends for organizations to query, so that they can ethically and in a sort of privacy maximal way host or access people's data because it is owned and hosted elsewhere.
Thank you.
Yes, do inquire.
Then finally, we have Professor Ryan Abbott, who's Professor of Law and Health Sciences at University of Surrey, and he hasn't put that he's also the author of The Reasonable Robot.
Well, thank you very kindly, and for the book plug, and I'm only paying him £1 per book sold for that. But it's a real honor to be here today, and I'd like to make 3 submissions to the group. First, it's not clear to me that ownership is the right way to think about data. It's common for people to speak about owning data, and it's a standard part of a lot of commercial agreements that someone owns data. But I'm not aware of any jurisdiction, including the United Kingdom, in which data per se can be owned. One can have various rights, even exclusive rights, associated with data. I may have a right to keep people from using certain sorts of data about me in ways I find objectionable, a right to keep someone from copying a photograph that consists of data, or a right for me to keep confidential business information. But when people speak about data ownership, they're really discussing particular rights and obligations about data. It conveys a sense of importance in places like here where personal property is an overriding interest, but it's not the right focus in terms of regulation. It's not the right focus because it involves a level of possession, control, and interest that would be counterproductive. And my second submission is that any system of data ownership would be problematic because it's not clear who should own data or that the benefits would outweigh the costs of any system of data ownership. If you think about the creation of intellectual property, it usually involves one layer of complexity. So we have a rule for when copyright subsists in something based on some sort of activity we want to encourage. So copyright can subsist in a novel, and we have a rule for when someone qualifies as an author. And we think that this works well because a system of property rights is a good way to encourage people to write books. Sometimes that gets more complex, or you have derivative works, or you have machines doing the writing. But the basic principle is that intellectual property law incentivizes socially valuable behavior we think would otherwise be underproduced. By contrast, the creation of data tends to be much more complex and to involve numerous parties and layers. Different parties may be generating data, aggregating data, structuring data, transforming data, analyzing data, and using data. And it would be challenging to come up with a workable system of rules across all instances in which one party there should own that data. And more importantly, it's not clear what we'd be trying to do with that system that isn't already happening. If we want people making databases or inventing new things based on data, we already have a series of rules for that in intellectual property law. If we want people generating data, including the public, that's already happening, either because it doesn't require additional effort or because they're getting some benefit from that. If you think of the example of a self-driving car and the data that will be generated from that sort of activity, which involves sensors and AI systems inside and outside of the car, you may have data about a vehicle's owner, its passengers, other vehicles, road conditions, pedestrians, and so forth. It's not clear who that data is about, and that's data that has value to a number of stakeholders, from insurers to sensor and vehicle manufacturers to the government. It's not clear that a single party should be owning that data, or that if we do let a single party own that data, we'll get more data or better uses of data. Because there are significant costs to property rights: transaction costs, administrative costs, compliance costs. More rights can increase complexity and add barriers to entry, particularly for small and medium enterprises, and more rights can also restrict competition and the rights of third parties. So my third thought is that data can deliver public value without being owned. It can be applied to research in ways that advances knowledge and contribute to the development of a variety of products that benefit the public, particularly products related to artificial intelligence. To the extent there's a concern that people should be getting more value out of data related to them, or that private industry is monopolizing the value in data, this may be something better distributed through taxation, ensuring that companies that are relying on UK-based data are paying appropriately into the tax system may redistribute value in a more efficient way. And to the extent that consumers or the public have concerns about the way data about them is being used, that sort of thing may be better addressed by privacy laws. So there's a critical role for regulation with data, but I think less with ownership than with things like safeguarding privacy, encouraging interoperability, and prohibiting anti-competitive behavior and discriminatory pricing. Just to tie into something Ellis said, to interact with one other speaker at least a little, he started off his remarks by noting it was kind of odd no one could own data, but there's these very important secondary uses of health information that are going to do all sorts of wonderful things, which I completely agree with. But again, it's not clear there that owning the data is going to make that happen anymore. It might just get in the way of things. Really, what we want might be a system of intellectual property rights that encourage people to use and share and analyze that data in ways that result in more innovation. So property rights that take into account what AI is doing now with innovation, particularly in health sciences. So machine learning approaches to innovation and making sure that patent law accommodates something like that. Thank you.
Thanks very much. It was all going so beautifully, wasn't it? Ryan, thank you. You obviously take a big tilt at the ownership issue, but why is that so controversial when really, if you substitute the word control, then you're going to get somewhere down the track, aren't you, in terms of the way that you regulate? Is it actually just a concept of ownership rather than the fact that you're trying to, in a sense, prevent use or sharing or whatever it may be? Is that a legitimate thing to be doing?
Well, I think there's two elements to it. So one is that being academic, we think about words more than maybe we need to. And yes, in some sense, practically it comes out to the same side, particularly if we're thinking about data a private party is collecting and storing in a database. They have the same sort of right over it. But, you know, as the use of a term, I think it conveys a stronger sense of ownership control than otherwise rights would. But as a practical matter, I think it comes down to Ellis's point. And then I could also perhaps tie this into James's point, right? Which is that, you know, the ownership is not at the lower level of facts and information being gathered. It is in the sort of uses people put to it, and it affects how the data is shared and aggregated. Right? If I buy something on Amazon and Amazon now knows what sort of tea I like, it's not clear that that is something that belongs to me or should belong to anyone, right? Maybe there should just be control over the way in which that sort of thing is used or who has access to it.
Yep, I understand. I think I may be on a similar page. Right, well, I think we'll open up and we'll have 3 questions. But first of all, I'll give Baroness Kramer the opportunity.
Baroness Kramer has to run to another meeting for which she's slightly late, but I did want to hear the end of our last speaker, so
Great.
I'm going to apologise and scramble.
Thank you very much. Right, well, we will. I've got one over there. Have I got a second question? Second question there, and a third question at the back. So 1, 2, 3.
My question is around what should be the final backstop around monitoring and governance. You talked about having human principles at the centre of things, and trust, and an empowered workforce to make, you know, exciting scope for innovation which people will know. But how do we ensure market practice that there is
It's really a compliance question. Yeah. Oh, sorry, but say where you come from. Where?
I come from city consulting firms in the Big Four.
Thank you.
Cyrus from the China AI Summit. My question is on international investment in data, UK data. Does the China find a case in terms of giving access to international conglomerates as well as sovereign that come beyond them for data investment rather than accessing UK data? You will set up a strategy where you access the data of the other side too.
Okay. And thirdly?
My name is Mohammed, and I'm Surrey University researcher, and I'm working on a decentralized compliant work for GDPR. My question is that I start with GDPR none of the GDPR clauses talk about ownership. So they talk about rights and controls. The rights and controls that are related to the user data, don't you think that we should include the consumer, the individual as values of right, of portability, access, and deletion. And then also, in terms of releasing the value, don't you think that data portability could save us from loyalty penalty? Because every consumer in the UK, they suffer with £1,410 every year, but being with the existing like insurance provider or any of the company they are with, don't you think we can use data on that angle as well? So get some benefit out of this?
Great, thank you very much. I think there's something for everyone on the panel. Who'd like to kick off? No compulsion to answer every question, just whichever ones take your fancy. I might start in reverse order. Ryan.
Right, because I did go last, and now I'm going to draw this out, thinking about it and saying it at the same time. Well, I think that the data portability question, which I'll remember because it was the last question, is a critical point and ties into, what on the far end one might also think of as anti-competitive behavior on the other, right? The data monopolies are making it difficult, particularly for small and medium enterprises to compete, and making it difficult for consumers to switch platforms. I think one of the very creative solutions to this is the hat model, where people control their own data and pass it along as they see fit, and that is one, right? And that other sorts of models for that exist and should also be explored, like promoting interoperability of data and data sharing, and having a role for regulators thinking about where firms need to be sharing data in secured ways to level the playing field for both consumers and other companies.
Thank you. I mean, Ryan, James, just in passing, while you're answering the question, I mean, do you disagree strongly with the difference, being made between ownership and control and regulation and so on? I mean, are you wedded to the idea of ownership?
Well, I mean, these terms can be used in different ways in different contexts. Sometimes ownership has a slightly, broader sense to it. A lot of the models for data trusts have this quite loose sense of ownership, but for us, we are wedded not only to control, to ownership and control together, and actual legal ownership. Because to take up on that part about GDPR, the GDPR gave a set of rights, extended some rights, gave other ones. But what one could say is that it didn't necessarily give people means of transacting upon them. The hat, by pulling it all together, it gives you, and then providing you a database of rights and contractual foundation, means that you can actually use those rights and have contracts coming out of those rights and have control out of it. So, yeah, I'd say it is important for us, ownership and control.
And then Andrew.
Yeah, I think if you're going to talk about value, I think it's only meaningful in terms of public policy if you put power alongside it. Because if value is about a conversation of people freely making choices, then the imposition of power into that can distort some of that. So we already see some companies will say to their workforce, here, have free gym membership, we will discount it, in return you can have a Fitbit, and buried within that, and we see lots of the US examples of that, is that the worker will make a choice of discounted gym membership because at point of use that may be a good thing, but sitting behind that is the accessibility of that health data to the employer, which allows a determination of choices or profiling of a workforce or selling that data on. So we often talk about the data life cycle, and much of our work is on the data collection point of where that data comes from, but the offboarding of that data, who uses that, who makes the choice, can workers block it, all comes down to that, where does power sit within that. So in terms of monitoring and governance, we'd always say, there's a saying we always use, which is nothing about us without us. And we've got to include the public, but also most of us as the public work, we've got to have a separate work conversation about what does that level of monitoring look like. Because most of these meetings I sit in, we end up talking about we need whistleblowing solutions. We need whistleblowing solutions, but can't we build a model which stops the need for whistleblowing in the first place by allowing that negotiation and conversation to happen at an early enough stage to avoid the need for whistleblowing?
That's partly your answer to the compliance question, is it? Yeah. Ellis.
Yes, I think I would agree with Andrew's comments on monitoring and governance. Obviously now, under the GDPR, you have an obligation to have a data protection compliance regime or program in place. I think previously, if you'd read the directive and the Data Protection Act, smart operators understood that that was implicit in that legislation. It has now been brought out as an explicit obligation under accountability. And I think that folds neatly into the point the gentleman from Surrey University was talking about.
Interoperability, citizens.
The GDPR, I think, is, when I very first read it, when the first draft came out, what I kind of took from it was that it represented perhaps an expression of some of the frustration, the European frustration, at some of the perceived processing and behaviours of the US tech giants. And so it does seek to try and put individuals back in the driving seat, to try and give them a sense of control and ownership, to use that word, of their personal data and what is happening to that data. And that is where data trusts and, interestingly, things like the Hat Lab come in, because they're tools that would help individuals feel that power, realise that power, and possibly then monetize that power. Now, whether or not that's a good thing overall...
You could use it in the employment workplace is another matter. I saw Andrew looking slightly askance at that point.
Well, collective bargaining comes in, and when I worked for a very large multinational, the Germans had a very, very powerful works council, and nothing was rolled out without they approved its rollout. Even something I would say as innocuous as an email system still had to have their explicit rollout. They wanted to see the data protection impact assessment. They wanted information pseudonymized as soon as it possibly could be. Yeah.
Tamara, do you want to pick up on some of these things? I mean, we haven't had an answer on the data investment aspect.
I'm not sure I'm going to be able to provide that answer to him. What I was thinking about listening to what was being said there is, in terms of this question of, I think one of the questions was who is the final backstop, who's the final arbiter of monitoring and governance, and I do think, to an extent, that is going to be the regulator. And I think as time goes on, as there's more guidance, more enforcement action, then you'll start to see that the scope of how that enforcement is going to work will come along. I think it's quite interesting how there's been a focus on transparency as a source of almost power for data subjects, which this idea that there's got to be notification of what's going on with your data.
It's relevant too to the investment issue, in terms of if the health service or whatever is going to do deals externally, then the transparency, is really important in this context.
Transparency is important, but there's also a question of transparency can sometimes be a bit of a red herring, because just because people know what is being done with their data, or they do if they read the privacy notice, and who apart from people actually read them. But there can be a red herring there, because there's a feeling we know what's going on with our data, so it's fine. Whereas, of course, what you really need is a backstop of the regulator saying, actually having some input as to, well, just because you know about it doesn't mean it's fine.
Thank you. And then Kenan.
Just to touch on the point of transparency, I think Tamara is completely correct. Just knowing what happens to the data is probably not sufficient. We need to empower individuals to be like, if I disagree with its usage, so for example, there may be international companies that we might, or even UK-based companies that we disagree with, and we should have the right to remove our data from that resource. It should not be just because it's out there and open and a company will say, this is what we'll do with your data. We should empower the individual to have an actionable impact on the use of that data, especially true for health data science. In fact, health data is an incredible resource. It can deliver incredible sort of public value, but we need to sort of get people on side into sort of how that data is being used. And I feel like with the services that are sort of free at point of access, or for example, the Fitbit example, how is that data being used on the workforce? How is that data being used sort of in the public space? And we don't really have any, not to my knowledge, we don't really have any tools to say, I'm not okay with this. And I think that would be important.
Okay, thank you. And then Florian.
Perhaps just to sort of share a general reflection that I think relates to several of the points that have been made, on also a couple of the questions. So it strikes me that a lot of the discussions we've had tonight evolved around the relationship between, on the one hand, individuals' interests and control over data, and then data controllers' interests, and questions of intellectual property rights, for example, and so on. I think it's very important to bear in mind. So I think those questions are very fundamental to a large part of this debate. But it's important to bear in mind that the interests that are at stake in the data governance context can't be reduced to these two roles. And what I have in mind is that there's a strong public interest case from an innovation perspective, especially for data to be available. So it's an interest that can't be reduced to the interests of individual data subjects. But it is an interest that's in tension, for example, with potentially with intellectual property rights in data, or sort of organizational control over data. Now, one might think that this can be taken care of by putting individuals in control, through data walls or accounts where individuals then are free to take the initiative, to share the data actively. But I think that's quite a big burden to put on individuals. I think we'd all very quickly be overburdened to keep track of all the beneficial opportunities that we should be sharing our data for. And so I think it's important to think about possible structures that maybe are able to fill that gap and sort of act as it goes back to Ellis's comment earlier about who has ownership of the sort of the opportunity cost of not using data.
It's one of the great dilemmas, isn't it?
Yeah,
I mean, the hat will be wanting to have the data, and you're saying, no, this is for public good, and so who's going to arbitrate in that sense? Quite interesting. Do you just want to come in, Jens, very quickly?
Yes, if I may. So firstly, I agree with all the points you were saying. I would emphasize that in the hat, we do have the concept, it's value co-creation. Obviously, a lot of this data is being produced by big companies or by scientists, and they should have a copy of it too, if that's the agreement between them. The second thing, though, I'd say, though, is yes, we are a core and individualist solution, but also, we do think there's a lot of grounds to, for instance, develop data trusts that operate on top of the hat. In a similar fashion to, property-owning democracies here, having trade unions in the past, we think this can happen in a data context. So, yeah, I'd welcome any exploration of that.
Great, thank you. I'm going to bring in Birgitta, Maria, and then have I got a third question? At the back. Right at the very far back. Great. So Birgitta, and then Maria, and then far back.
Okay, so we talked a lot about value and rights and ethics. A couple of weeks ago, I was in a round table with several cloud computing companies, and one of the issues they thought was a big challenge is that as we have, of course, we're all doing, interacting with clouds, whether it's banking or energy or HR, and all these clouds have interfaces, and the data flows between them. And one big aspect, of course, is data security of these interfaces. But another issue is that if we're bringing back the kind of the full control to the individual to make every single decision, then of course we have the situation that some of these clouds that needs to communicate all of a sudden cannot do it because somebody has agreed different rights to different clouds. What that has, the knock-on effect of that for the cloud providers is that we get bigger and bigger monopolies because they take everything. So why not just create why not think for the individual that we actually get more competition if we actually agree on some standard governance structures around what good looks like, and then it's only in extreme circumstances, or not extreme, but in bigger circumstances, we actually ask to put our view. And is there any kind of thought about the functionality of actually this kind of individual data control?
Thank you. Maria.
Yes, hi. We talk a lot about data and using AI, aligned with the value creation, but we don't talk enough about the context this value creation happens, which are the data-driven business models. The fact that neither European Union and not of any regulators, legislators around the world seriously talk about how do we look at business models invented by Google, Facebook, Amazon, and all the others to meaningfully address the issues of power asymmetry, data ownership, data creation, and so on and so forth. The reason being is twofold. First, they created a business model that now seems to be the go-to business model for everyone. Everyone aspires to be as efficient as Amazon, as efficient as Google, and being able to use or valorify the data as Facebook. Secondly, is those companies have done a pretty good job to kind of hide the business model and how they operate. And it's very difficult for regulators or for anyone who is trying to question those big corporation black boxes to go there. So what do we do about it? Because that's the big elephant in the room to me, and no one is talking about it clearly.
Thank you. Very topical in the light of the Centre for Data Ethics and Innovation's paper on online targeting too. Gentleman at the back.
My question is, what is the valuation of data, and how could you procure and save people's data on a larger scale, and rural areas where people's culture and their cultural background is not on them sending their data because they don't have no knowledge of it, and how would you actually teach people about artificial intelligence and how to basically use it and utilize it more better as well and more efficiently as well?
Thank you. Right, well, we've got 10 minutes and we're going to run through our panel in the opposite direction, but I think one of them has had to leave, is that right? Yeah. You're in the... Florian's had to leave, obviously. I'm going to start with Kenan and we'll move down the line.
Okay, so I think I will pick up from the last question. So it's very easy to sort of... well, actually, so maybe this tackles multiple questions. So I agree. How do we get big companies to sort of open up, what it is that they do with their data? They will probably hide behind competition rules. Sort of obviously, they don't want to make their data, their practices open to their competitors because they might identify a weakness or something that they could exploit, which is their thing. But the gentleman was right. I think it's fair, probably it's fair to say that we place an inherent value on the data, but we do very little to capitalize on it. So in the curriculum for sort of health data science, there are modules to help understand sort of what data is being collected about you and some of its uses and how that sort of does good, and equally what are the less good things about that data, sort of how is it used for describing a risk category of a group of individuals that might change sort of whether or not you get approved for a mortgage or car insurance, for example. And we need to be very clear that this data is out there. It's very difficult, or if not impossible, I would argue, to get that data back, and that we just have to be very careful about what it is that gets released about us.
Trouble is there really a set of norms? I mean, the gentleman wants people to understand what the value of their data is, how it's being used. Bagita, on the other hand, may have a different set of ideas about the benefits of data being in the cloud and so on, and competition being what really should be the object of data use and so on. So this is not settled yet, is it really?
No. It's a constantly sort of rapidly evolving landscape. So these risks that we face are dynamic, right? So the risks today, sort of knowing how this data is used, might change in 5 or 10 years' time. Like, we don't know what the full implications of releasing this data into the wild and sort of how that gets used. But in the same way, sort of, and I think this is part of the regulators, that if those companies, if those very large international companies are not willing and to sort of release sort of their data usage and their products and values based off data being collected on the consumer. Then we need to maybe think again sort of how these companies are able to operate, what licenses are given to them in areas of in sort of countries. Are they allowed to operate sort of in England, in the UK, depending on how they fit the law?
Well, Desiree is going to pull together the whole thing in a wonderful way that will bring us all to a very good set of norms and understanding of all of this, I'm sure. Right, Tamara.
I just thought it would be interesting to pick up on what Birgitta was just saying there about the idea of perhaps standard governance structures and ethics structures to help relieve the burden on individuals. I think that's a really interesting idea. And you know, from a point of view of a non-specialist company or organisation looking at this world, there is a bewildering array of organisation, ethics structures, and so on that seem to be out there. And even as a specialist, it can be quite hard to follow. And you know, we spend a lot of time drawing diagrams of this to try and understand.
Not if you read the ICO's documents.
And so it is quite bewildering. So in a way, although this is a bit of a holy grail, it would be great if there were some generally acknowledged good practice standards which people, so you know, organisations do not have the resources to be making these decisions for themselves in many cases. So it's great for them to be able to sort of go somewhere where there's something generally acknowledged and to say let's take that. I think that's quite useful. I think the idea of and data trusts or hat-like structures could be part of that. They could sign up to some of these codes.
I mean, you can do some of this stuff, Ellis, but it's the valuation stuff, isn't it? Which is isn't that the tricky bit? What should be private, what should be public, and so on.
Yeah, and I think that's part of the kind of wider debate. How are we? I would suggest through refracting these issues through an ethical lens. How are we going to agree as a society where the value, burden, and benefit? How is the cake divided? So I think it's, have you finished one? Right. I'll launch in very quickly on Brigitta's, the kind of breaking up of monopolies. And I think somebody in this room will have a better memory than I do of my data, which was in the UK, years ago. And it just never really took off. And it was about empowering the consumer and encouraging portability. And then we see that crop up in the GDPR text. I think the Europeans looked at what the UK had tried to do and decided that was a very good idea. And the portability right does talk about interoperability. So I think the bare bones of that are there, and then it will be up to consumers possibly to pick up those rights and exercise them in a meaningful way. The kind of what's happening behind the facade potentially of some of the US tech giants. So obviously, as I said, the regulator does have the right to inquire of organisations as to their data processing, and obviously misleading the Information Commissioner is quite a serious offence. But we were talking earlier about the backstop, and it occurred to me that, of course, we now under the GDPR have what I would call a group litigation order, but collective actions are now possible. And obviously, BA, we've announced our intention to levy a monetary penalty, but there is a law firm out there trying to put together a collective action for people, and that anything that the court would award would be in addition to any fine which we would additionally levy. And you don't even need, under the GDPR, to have one of the negatively impacted people sign up. Just civil society organisations may pursue those collective actions by themselves without having a kind of representative case sample behind them. And I heard Marcus's question around, did I mishear it? I thought it was about the digitally disenfranchised and marginalisation of society.
It's people understanding, I think, how their data was being used and the value of their data, wasn't it, effectively?
Okay.
Yeah. Thank you. Okay, Andrew.
Two things. Firstly, I think we need to, in some ways, despite this, stop being mesmerised by technology and regard it as this is about an economic model that we're in, and actually the things we need to fix are the economic model that drives behind this, not the technology. And we get that really confused some of the time because it's newness. So we need to stop saying it's the future or the future of work, because it's happening now. And every time we say future, it enables the slow tail of regulation, which is always slower than innovation, to slow down even further because we think we have time. And secondly, talk about the economic model. But, you know, historically, we know that, you know, when there is major economic change, there are winners and losers. There have always been winners and losers. We have tended to act when there have been major disasters or outrages which have forced nations or publics to come together, or where people have collectively organised. And it's not a case to say we should turn back the clock on things, but actually the things that, you know, we don't kill people at work because we have a health and safety regime which wasn't handed to the nation. People fought and struggled to get it. And actually we need an understanding of where capitalism is. We need my lot of people in unions, but also people like the FT who talk about what does capitalism look like. How do we bring a human face to our economic model, not just a human face to technology? And I think that's where we've all got to come together, because fix the regulation, but create a society which understands where power and responsibility lies.
Thank you, Andrew. James?
Yes, I'd just like to fully agree with the previous statement. You know, so much of the time we clothe these things in exciting and quite difficult to pin down abstractions like ethics, but often we're talking about economic and historical forces that can be subjected to exactly the same kind of analysis and reaction as in the past. Surveillance capitalism, which I'm sure a lot of people here will have read, very much situated the model of surveillance capitalism as a business model in terms of pre-existing waves of capitalist extraction and profit. I think having said that, and, you know, bear in mind then trying to be a bit more practical about it, there are lots of interesting things you can do. For instance, in relation to the surveillance capitalist model itself, as it would relate to the HAT system, we have a quite well elaborated system of governance and incentives, and actually have a system wherein people who develop using the HAT are increasingly encouraged to basically query the HATs as their back end, people here being organizations and corporates, querying the HATs at specific moments for specific bits of information, rather than just the kind of wholesale data stripping and copying that would be, you know, quite a dominant model, I dare say, at the moment. So there's lots of things that can be worked on there. There was a question at the beginning of the three regarding, I guess, data monopolies and the promotion of competition. Obviously, these are gigantic questions. I do think, depending, as always, the devil is in the detail. You know, you could say, well, maybe certain systems that provide ownership will ultimately lead to greater monopolies, and, you know, wrongly structured, yes, they could. As far as we see it at the HAT, the ability to have data portability and for individuals to, you know, if not quite necessarily own their data, then certainly own the vessel for their data, will promote competition in the long run, because a lot more different types of data can be spread around a lot more easily by the HAT owners. And as for the question on social engagement, I think it's a very large and important task, and certainly in the HAT Lab with our events program and our forthcoming set of publications, we'll be trying to do our bit for that.
James, thank you. And then, Ryan, you get the final word.
All right.
Dangerously.
Indeed. Well, a lot of this has touched on some critical issues, monopolist practices, people being left behind. Some of those, I think, have very technical, narrow answers about what regulators and antitrust authorities should be doing. But I think really they both get to fundamental issues with distribution in society. As Ellis put it, how is the cake divided? And I think that the challenge of AI is that it's going to disrupt the cake. It's probably going to make the cake bigger, and yet some people are going to be eating smaller slices of cake. And I think the solution to the cake problem is to have a tax system that accommodates AI, that is more progressive, and that ensures that as the cake gets bigger, we all get to benefit from it. And some obvious solutions to that involve funding education programs and social benefits, and potentially ultimately something like a basic income. I think the opportunity of AI, though, is it gives us a chance to take a step back and say, you know, how do we divide cakes in the first place? And have we been doing it right? And let's just rethink cakes.
Great. Ron, thank you very much. And can we thank our panel very much indeed. I think you'll agree we've had an extremely stimulating discussion about an area which is really not easy. I mean, all the concepts that we've talked about today, you know, the public-private benefit, the ownership control, all the issues of intellectual property and so on, they're areas that everybody is still grappling with, basically, and yet we have the GDPR there that is probably not totally fit for purpose for the future, and we have quite a lot of decisions to make in the future about how we move forward on all of this. But I think we've had a very, very interesting snapshot from all sorts of different angles here, and I'm extremely grateful to the panel for a very, very stimulating discussion. Thank you very much, and thank you for all your questions as well. Thank you.